All right, we are now live on YouTube. Let's go ahead and get started. Mr. McLaughlin, you've given me a reaction button. Are you ready to have your case called?
Yes, sir. I have two cases. The first one is portfolio recovery versus Angel Perez.
All right, that's CL 19-1504H. Portfolio Recovery Associates LLC versus Angel Perez. This case is set for dismissal for want of prosecution as no one appeared on March the 10th.
I believe a motion for default judgment was filed, sir. And if possible, would like to prove it up.
All right, was it filed in? All right, was Angel Perez given notice of today's hearing?
To the best of my knowledge, she was given notice of the DWAP hearing for today.
They were told to submit an order seeking from the last hearing. They filed the order seeking, but not till this month. So it's not
Okay, so I'm going to need to give you another date, Mr. McLaughlin, because you all filed the order setting hearing on Monday. So
Okay.
the respondent Angel Perez wasn't given notice of the default. So let me go ahead and reset this for 30 days so that we can give notice.
And I have a second case that I would like to reset for 30 days as well.
Sure, give me 1 second. May 9th for this one. May
Yes,
9th at 9:30 for the Angel Perez case. And then the next one that you have?
Is 18-4136H, JH Portfolio Debt Equities versus Martha Reyes.
And that one is scheduled for a default judgment hearing, and you're asking for 30 days?
I'm asking for 30 days, sir.
Can I give you the same date, May 9th?
Yes, sir.
All right, May 9th at 9:30.
Thank you, sir. That's all I have.
Thank you. All right, Mr. Juan Angel Guerra, you have CL 220576H, Heriberto Castro versus Road to Investments LLC. I believe last time you were here, Mr. Guerra, you announced that the TRO was to expire by operation of law, and we set this up as a DWAP to make sure that, you know, we closed out the case.
That's correct, Judge. This was one of those cases where how the TRO is supposed to work. It was a very successful. He was about to lose his $500,000 business, but because of your TRO, we appreciate it, Judge. We were able to sell his business at a profit and took care of that. So both parties are happy, so we're dismissing. So go ahead and dismiss, Your Honor.
Okay, perfect. This case will be dismissed. Thank you so much for that announcement.
Thank you, and thank you so much for your TRO. It really helped my client, Your Honor.
Good, I'm glad.
Thank you, Your Honor.
Thank you. Okay, is anyone else ready to make an announcement where the parties are present? Mr. Gomez.
Your Honor, good morning. F 4429-188.
In the interest of Elaine Arriaga Bernal et al. Children?
Correct.
All right, Mr. Reyes, are you ready for that case as well?
Your Honor, I'm not ready to proceed on the final hearing to resolve this matter. I was hoping to have a little more time to confer with Mr. Gomez about the issues in this case. Currently the order as it stands has the pickup and drop off in McAllen or Sherry Road in Mission, Texas. However, my client resides in Houston and he's still trying to get his immigration papers in order. And so he's been unable to see his children for quite a long time, over a year. That's really one of the issues that I was hoping to confer with Mr. Gomez about and see if we can come to an agreement on this. But I did, this morning, I did submit a proof of income. I emailed Mr. Gomez. So maybe we can be placed into a breakout room briefly, Judge, to see if we can't hammer this out or.
Sure, I can do that. And then if y'all need more time after that, then let me know.
Thank you, Judge.
Okay.
And Your Honor, Elias Alcantara, the Office of the Attorney General, I'm also on that case. If you could please place me in the same breakout room.
Absolutely.
Thank you.
And my client is logged in, Judge, under Isidro.
And would you like him to be placed in the room?
I think at first we can go with the attorneys, Judge, and then I'll follow.
Sounds good. Sounds good. The invitation has been sent. Please accept it and then come right back. Let me know how it went.
Thank you, Judge.
You're welcome. All right, Mr. Benavides, what case are you here on?
Good morning, Your Honor. I'm here on CL 194296H. It's a traditional and no evidence motion for summary judgment. May take a little bit of time, so you might want to come back to us.
Okay. Mr. Chapa, I understand you had a new baby. Congratulations.
Thank you, Judge.
The fact that you're awake right now is a miracle to adrenaline and being a new parent.
Basically, Judge.
All right, hang tight. We'll be right back with you.
Very good. Thank you.
Ms. Bettis, you have P006122-8, Amanda Denise Alvarado and Jose Luis Ramirez Jr.
Yes, Your Honor. Delegate Bettis on behalf of the applicant. I believe she's logging on right now. I just got off the phone with her. And I believe he's on the Zoom as well.
Yes. Mr. Ramirez, are you represented by an attorney?
No, sir.
Okay. Then let's hang tight for your client, Ms. Bettis, or would you like to proceed without her?
No, because I need her to go forward. We're ready to proceed on this case it's a protective order.
All right. And was Mr. Ramirez served? I assume since he's here?
Yes, sir.
Yes, he was.
Okay. I think I see your client logging on right now. Mr. Ramirez, are you prepared to go forward at this time?
Yes, sir.
Okay. All right, Ms. Amanda Alvarado is connecting. It looks like it's connecting to the audio. All right, Ms. Amanda Alvarado, can you hear me? And if you can you please unmute yourself?
Yes, I can hear you.
Perfect. And I will need you to turn on your camera, please.
Okay. Hello.
Okay, thank you so much. Let me have Mr. Ramirez and Ms. Alvarado, please raise your right hand, both of you, please. All right, do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I'm going to start with Amanda Denise Alvarado.
Yes.
And Jose Luis Ramirez Jr.
Yes, sir.
Okay, you may lower your hand, Mr. Ramirez, and I only swore you in case you testify or you give any information, you're under oath, okay? Ms. Bettis, I will now open the floor to you and how you wish to proceed.
Okay, yes, Your Honor. Ms. Alvarado, can you please state your full name for the record? Ms. Alvarado, can you hear me?
Yes, ma'am.
Okay, can you please state your full name for the record?
Amanda Alvarado.
Okay, what is your address?
My current address is 3805 Tulipan Avenue,
Okay, in what city?
Mission, Texas.
Okay, and you are the applicant in this protective order P006122-8?
Yes.
Okay, and you filed this application for protective order against Jose Luis Ramirez Jr., is that correct?
Yes, ma'am.
Okay, and what is his address or his, what is his address? Do you, if you know that?
I think it's 221 Rafael Street, Sullivan.
Okay. In And where now?
Sullivan?
Sullivan City?
Yes.
Okay. All right. And how is it that you're, what is the relationship between you and Mr. Ramirez?
He's the father of my kids.
Okay, so he's the biological parent of, or you're both biological parents of children, is that correct?
Yes, ma'am.
Okay, and at one time, were you all living together?
Years ago for like a month,
Okay,
a couple of months.
okay. And then you all have, what are the names of the children that you have?
Jackson Alvarado and Nathan Ramirez.
Okay, and can you tell us about the incident that occurred on January the 24th of 2022?
Where do I start? I was having some problems with my mom, and she started getting aggressive. She hit me. And then,
Okay, let's keep the, what happened between you and Mr. Ramirez on January 24th?
I'll start there.
And I'm sorry, but I'm having a real hard time hearing you. I don't know if the judge is as well, but I don't know if you can raise your volume.
Losing my voice a little bit. I'm sorry.
Oh, okay, I'm so sorry.
It's okay. I called Joe to pick up the kids so that I can figure some stuff out. I told him to take him to his mom's house. He said he was. I went back home to pick up some stuff, and I saw my kids there. As soon as I entered the home, my brother started choking me, so I took my kids out. And as soon as we got to my friend's car, Eliel, Joe came running out of nowhere, attacking him, threatening him not to get near his kids or something like that. I couldn't hear him. After that, he yanks the kids out of the car. I tell him to stop, like to let me take the kids. It wasn't a safe place for them to be. And he starts hitting me and throwing me to the street.
Okay, hold on. When you say he started hitting you, what exactly was, or where or how was he hitting you?
Right by the car in the street.
Okay, and
Like,
where on your
that-
body was he hitting you?
My face,
Okay,
my head.
okay. And was there anything else that he did to harm you or to hurt you?
He would grab me and throw me to the ground, and the kids would fall and they were crying, let me go with my mommy, let me go with my mommy. He wouldn't let them.
Okay, and were the police called that day?
Yes, I called them.
Okay, did they show up?
Yes,
Okay.
right after. My mom says that he ran, and my kids say that he hid in my restroom.
Okay, well, when the police got there, was Mr. Ramirez still there?
I don't know. The kids say yes, and my mom says that he left running.
Okay, and how is it that you don't know? Did you pass out or were you
No.
unconscious?
Yeah, I did pass out for a little moment because he was hitting me that hard. And
And did you have to go to the hospital?
no.
Okay,
All I wanted to do was to get away from that place and get somewhere safe.
okay. And so as a result of that particular incident, is that why you decided you wanted to file a protective order against him?
Yes, because it's not the first time he hits me.
Okay,
He's very violent.
okay. And is that why you're not together?
Yeah, that's a big reason why.
Okay. Judge, I have a I have a police report that was filed into evidence as Exhibit 1. Can I share the screen and
Sure.
being able, okay,
Let me open it up for you. All right, go ahead.
okay, let me just find it. Okay. Amanda, can you see this, the screen, what's being shared on the screen,
Yes,
which
ma'am.
shows as Exhibit 1?
Yes.
Okay. Is this a police report from Mission PD? Can you see Mission
Excuse
PD
me?
written at the top?
Yes.
Okay. And so it is is this a case report that was filed by the Mission PD for the incident on January 24th of 2022?
Yes, ma'am.
Okay, where the it shows that it was an assault causing bodily injury
Mm-hmm.
with the suspect as Luis Ramirez.
Mm-hmm.
Did you give a statement to a police officer on
Yes,
that
ma'am.
day?
Yes, and my friend did too.
Okay. Judge, I'll offer this into Exhibit 1 into evidence and offer it to Mr. Ramirez for any objections.
And a lot of neighbors did too.
Hold on, Miss Alvarado.
Mr. Ramirez, have you had a chance to take a look at this police report?
Yes, I've also been interviewed by the Mission Police Department as well already.
All right. Do you have any objection to Ms. Perez introducing this as evidence?
Is this the complete report or is this just the initial report?
Ms. Perez?
That's all that was issued to us by the police department. That's all they'll give us because it's a pending investigation.
Okay, so this is just the, I guess, the information copy, right? The information case field.
Correct.
Okay.
Yes.
Okay, yeah, you can turn it in. I don't mind it.
Exhibit 1 will be admitted without objection.
Okay. Thank you, Judge. And Ms. Alvarado, to your knowledge, has there been an arrest issued for Mr. Ramirez for the assault against you on January 24th?
No.
You don't know anything about that?
About what?
About him, was he ever arrested for the assault against you?
No, he wasn't. My mom told me that he was, but she lied.
Okay. Okay, but you did file charges and you told the police you wanted to file charges against him. Is that right?
Yes, ma'am.
Okay. And are you asking this court to grant a protective order against Mr. Ramirez? And you would like him to not be committing any family violence against you, not communicate with you or any of the people that live in your house?
Yes, ma'am.
Okay, and would you also like the protective order to include that he doesn't go near you, your residence, or any place of employment?
Yes, ma'am.
Okay, and would you also like the protective order to include that he not possess a firearm for the duration of the protective order?
Yes.
Okay, and Judge, I'll pass a witness and I have no further questions of Ms. Alvarado at this time.
All right, Mr. Ramirez, do you have any questions of Ms. Alvarado?
No, not yet.
Okay, Ms. Perez, do you have any questions for Mr. Ramirez?
No, for Mr. Ramirez, no.
Okay. Mrs. Alvarado, I have a couple of questions. In your protective order supporting affidavit, it states on January 24th, 2022, at approximately between 8 to 9, I went to my mother's apartment where I had been residing to pick up personal belongings. My friend Eliel Delgado came with me. My mother, Sonia Torres, had kicked me out of the house and I was not staying there at the time of the incident. It goes on to say, when I show up at my mother's apartment that same evening, I was surprised to see both my sons at my mother's residence. I proceeded to go into the apartment to gather my things, and I am immediately physically attacked by my brother, Daniel Adam Alvarado. He choked me. I quickly leave and take my two sons outside with me. And I believe it says, and as I'm making my way to my vehicle, Jose, my ex-boyfriend, appears and starts physically attacking me. Now, did you file charges against your brother?
No,
Did you file a protective order against your brother?
no,
Did you say here that you were choked and physically attacked by your brother?
yes,
Okay, so I'm assuming that you were showing visible signs of that attack as well?
yes,
Okay, and so when you filed this police report, you were showing visible signs of being attacked by your brother, maybe some visible signs of being attacked by Mr. Ramirez, but you didn't press charges against your
Well,
brother.
he was just choking me. He wasn't hitting me in my head. I had actual bruises and cuts in my head.
Okay.
And I have pictures.
Okay, and how, I guess I'm trying to figure out, how do I differentiate between the fact that you were physically attacked by your brother and you're claiming that you were also physically attacked by your boyfriend, ex-boyfriend? And I'm trying to reconcile this, is what I'm trying to do, right? And then the fact that you didn't press charges against your brother, only against your ex-boyfriend. And
Because
the
I
fact,
can stay away from my brother, but my ex-boyfriend, he actually has to communicate with me and exchange children, and
okay.
I don't want him near.
It says here, every time I tried to get my son, Jose pushes me and punches me, throwing me to the ground. Is that at the time or every time you try to, you all have any communication
In the incident.
in the incident? Okay.
Mhm.
Okay. Mr. Ramirez,
Yes, sir.
or Ms. Pettis, do you have any other witnesses or any other questions, follow-up questions to Ms. Alvarado?
No, Judge. Oh, just for Ms. Alvarado, one more. Ms. Alvarado, did you want to have the kids included in the protective order as well?
There are
course.
already.
Yeah, they're already included.
Okay. Oh, I just wanted to get that on the record though, Judge.
Oh, okay. Yeah.
Yes, okay. And that's all the questions I have, Your Honor, for Ms. Alvarado.
Mr. Ramirez, any
Yes, sir.
questions or anything you'd like to say on your behalf?
Yes, sir. Can I start with my side of the story as well now?
Well, I mean, you can give me your side of the story, but okay, yes, I guess since you're representing yourself, the answer is yes.
Okay, cool. So when I got there, I picked up my kids at her aunt's house because she wasn't at her house. So I picked up her kids, and then from there I took them to her mom's house because she was taking care of them for that night because the next day I had school. So when I left to get my son some lollipops because he had broken the one that he had gotten. So I got, like, when I was at the store, I got a call from her mom saying that Amanda was taking the kids.
Objection to the
No.
relevance, Judge?
I'll overruled. I'll allow it. Go ahead, Mr. Ramirez.
So then I got there, and yes, I went running towards the house, and they weren't there. And as soon as I got there, I saw Amanda on the phone pacing front and back at the parking lot. And then I saw some other guy, like, putting the kids inside the car.
Mhm.
So I went there and I ran towards the guy, and the guy ran toward, like, he ran away, and he took off his hoodie, and it was somebody that, like, I had met before. So I met him, and then I told Amanda to give me the kids because, like, they weren't safe with her because
How
she
do you
knows
know that?
why. Because she's never been there for the kids. The mom has always
I
been
don't have
taking care
you.
of the kids.
Objection, Your Honor, as to,
No.
objection as to the
That's
relevance.
not,
All right, okay. Ms.
Amanda, Ms.
Alvarado,
Amanda.
Ms. Alvarado, your lawyer will have a chance to cross-examine Mr. Ramirez. That's why you have a lawyer. We're not street fighting here. This
he's
is.
lying.
I understand that you disagree with what he's saying, but he didn't interrupt the questions between Ms. Pettis and yourself. So please don't interrupt him. He's representing himself. He's doing what he needs to do at this point. You may disagree with him, but your lawyer will have an opportunity to ask him questions on your behalf, okay? Now, I'm gonna mute you because don't seem to be wanting to stay quiet during his testimony, all right?
I'm sorry. No, I won't.
All right, Mr. Ramirez, you may continue.
Okay, so then like I got there and then I saw her and I told the kids like I'll take them, like just that your mom has to take care of them today. And she was like, no, I'm gonna take him to my boyfriend's or wherever she's. I don't know where she was taking him. So then I grabbed her and then I started pushing her. I didn't hit her. I did push her. I grabbed one of the kids and I took him inside I was grabbing him. I grabbed one of the kids and I was taking him towards inside of the house of his mom's house, of Amanda's house. And while we were heading that way, like she kept hitting me. And also she even ripped my shirt and she hit me in the head with her cell phone. And as soon as I put both kids in, there's 2 doors to that main entrance, to that building, to that apartment complex. So I was putting the kids in through one door and I threw them in and I shut the door. And as soon as I shut the door, I went through the front door and left. Why? Because we were already in an altercation. Like she was pushing me and she was
Okay,
hitting me.
Mr. Ramirez, let me understand this. You had possession of the children at the
Yes.
time?
Yes,
Okay.
sir.
And how did the children end up at the children's
So,
grandmother's house?
I took them there.
You took them there.
Yes, because she was gonna take care of them for that day because the next day I had school at 8 in the morning.
All right. And so you took them there and left
Patty.
it there.
Yes, I left them there with her, in her care.
Okay.
She was gonna take
And-
care of the kids.
And you have a good relationship, it seems like, with the maternal grandmother.
Yes, that's the person that I would talk to before, and we will do the interchange of the kids because me and Amanda, we can't. Like we always end up arguing or something.
Okay.
So that's why me and her would always communicate, and I would pick up the kids and stuff like that with her.
Okay. And when you showed up, had you seen that there had been a physical altercation between Daniel Adam Alvarado and Amanda Denise Alvarado?
No, I went straight. I didn't even went inside the apartment. I just went straight to the parking lot.
Okay. And the parking lot in an apartment complex?
Yes, sir.
Okay. And you went there because the children were in the car?
Yes, because the mother had called me to tell me that she was taking the kids away.
Oh, so you arrive and the kids are already in the vehicle of Miss
Yes.
Alvarado,
Yes, sir.
and you immediately go to the vehicle.
Yes.
Prior to this, and maybe Ms. Bettis, you can help me understand this. Prior to this, there had been no SAPSR, no orders for custody or for
No,
possession. and
No,
action.
they do have a SAPSR in place.
Okay, and who has primary residence of the children?
Yes.
Miss Alvarado.
Okay, and so, so did you have the children that weekend or that at that period of time based on the orders?
No,
Okay, why did you have the children at that time?
because she called me for me to go pick up the kids.
Okay, because she was going to be doing something.
She was gonna be busy.
Okay, so by mutual agreement, you had possession of the kids during that period of time. And during that period of time, you were going to get busy. So then you left them with the maternal grandmother.
I was
Or-
gonna leave them overnight because in the morning, the next day in the morning, I had class.
Okay. And that was by mutual agreement.
Yes.
Okay, but when she went to go pick them up, they were still, that was during her period of time, right?
Yes.
Okay. And so you were upset about the fact that she was going to take them back, or what was your issue with that? If you hadn't seen the fight altercation, because
I just wanted for them to stay there with her mom and not go with her since.
why
she-
though? She has access to the children.
Yeah.
They're under her custody,
Yes,
right?
sir.
You have primary custody.
Mhm.
So why did you have a problem with her going and
Because
picking
I
them
don't want
up?
for her to take her to wherever she's taking the kids.
Okay, but how is that of an issue? Like, I mean, she has primary custody of the children.
Yes, sir.
Okay. Here's what I thought, Mr. Ramirez. At the beginning, I thought when I read the supporting affidavit and I saw that she was being physically attacked by her brother, and then
Yeah.
you come in and swoop the kids. In my mind, I'm thinking, hey, protective dad is trying to protect the children from this incident that's happening remove them from the situation, but you
Yeah.
just testified that you didn't even see that altercation.
No,
You just went straight to the car because you didn't want for mom to take the kids with her.
yes,
Okay, but it wasn't even your weekend, or it
No.
wasn't your period of possession.
no,
Okay, all right. And so then you take the kids, remove them from the vehicle, and that's when she physically attacked you, according to you.
mhm,
She's claiming that you attacked her, and so
Mhm.
it's a he or she said kind of incident at this point. Okay. Okay, all right. Anything else?
well, the other thing is, does this protective order goes both ways? Like if she has a protective order against me, can she contact me?
All right, well, that's, I'll allow Ms. Pettis to answer that because we start getting into legal advice and issues.
Yeah,
Okay.
no, yeah, well, we're not asking for it to be mutual. We're just asking, we're asking for one against Mr. Ramirez at this point.
Can I ask, can it be mutual? Because she
We would
seems
not
to
be
be
in agreement
bothering
with
me, because she seems to be texting me and bothering me still.
When was the last time she texted you?
It was on Friday or Saturday. I
Of
think it
this
was Saturday.
This Saturday?
Yes.
All right, and what was the nature, without going into details, was that was that a text message about the kids?
Kind of, but not really. It was Saturday at 6:38 p.m. I have it here.
Okay, but did it involve the children?
Not really. It was just talking about me, telling me stuff and stuff like that. Like telling me off. I can read it out for you if you want.
I would object. I would object to him reading anything. We can, if they've got a screenshot of it that can be entered into evidence, but I would
Mhm.
object to that.
All right. That will be sustained. I don't want to complicate the matters. Now, obviously, though, you're asking, Mr. Ramirez, you haven't filed anything. You haven't filed a request for a mutual protective order that it go both ways, correct? You haven't filed anything?
No, I have no lawyer. I have nothing yet.
All right, and why do you feel that you would need a protective order against her?
Because it's the same reason, sir. Like she's the one that's the reason I left, because she's hitting me. She would be hitting me and stuff. She's the attacker, but yeah, she wants to play the victim.
Her mother,
Mhm.
I know I read it in here, and it might have been in her own words. She says, my mother and my brother are on Jose's side and they will protect him.
Did she also say that she accused me and the mother of having an affair to her whole family?
That is not in the affidavit, no.
Yeah, she started that rumor with their family.
Objection, Your Honor, is to relevance.
Okay, sustained. Okay, Ms. Pettis, do you have any questions for Mr. Ramirez?
Yes, I do have a couple of questions.
Mhm.
So, Mr. Ramirez, is it your testimony that you deny hitting Amanda?
Yes,
Okay, and is it your testimony that you have not been arrested by the Mission Police Department for an assault on Ms. Alvarado?
yes,
And is it your testimony that you left the scene before the police could get there on January 24th? Is that correct?
I didn't know the police were called. That
Okay.
I left for my own safety. I
Okay,
didn't leave because of the police.
okay. Once there was an altercation, then you decided you were going to leave the scene.
Yeah, that's
Okay.
what I would always do. She would hit me and I would leave.
Okay, thank you for answering the question. And so it is your testimony that you did not have possession of the children that particular day. Is that correct?
No,
Okay. So then if the fact that Amanda was going to her mother's house to go pick up the kids who
Mhm.
she had possession of, you just didn't like the fact that she was going to take them somewhere that you didn't know where she was taking them. Is that correct?
yes,
Okay. But at any other day of the week that she has possession of them, you don't know where they are either. Isn't that true?
yes, they're with their mother, with Sonia. because
That they
Amanda
have
would,
possession. Okay, but the court order says that Miss Alvarado, Amanda, has possession of the
Mhm.
children.
yes.
So wherever she's living, isn't it true
Yes.
that wherever she's living,
Mhm.
that's okay that she has the children there? Isn't that true?
Yes. But
Okay,
the
because
question
that's what
is,
the court order says, correct?
can she stay there? Can the kids
Okay,
stay there and
Mr.
she
Ramirez,
leave
hold
for
on.
2-3
You
weeks?
didn't answer my question. So wherever she has the children, that's okay because that's what the court order allows her. Isn't that true?
Yes.
Okay, so it's not up to, so isn't it true that it's not up to you to
Mhm.
dictate where Miss Alvarado can take the children? Isn't
It
that
goes
true?
both ways, right?
So according
goes
to the
both
court
ways?
order,
Does it go both
According to-
ways?
okay, I'm asking the questions now.
No, but
and
I'm
the
asking you
question
something
is-
back.
Mr.
So I
Ramirez,
can know it's
Mr. Ramirez,
Yes,
Mr.
sir.
Ramirez, I'm gonna tell you the exact same way I told Ms. Alvarado.
Mhm.
Answer the question. You're on cross-examination right now. This is not a
Oh, okay.
debate. This is not a who can yell louder. This is not a, I'm gonna get mine in. No, we're not, again, we're not on the streets of Sullivan City here. This is a court of law. Answer her questions. That's it. If you have another follow-up question, I'll give you the opportunity to do that.
Yes, sir.
All right, Ms. Pettis.
Okay, so wherever she has the children,
Mhm.
according to the court order, she has that right to do that. Isn't that
Yeah.
true? Okay, just like you, when the children are in your possession
Okay.
during your times, you can have them wherever you want them. Isn't that true?
Yes.
Okay, all right. So the fact that she had asked you to take them that day and you ended up not being able to take care of them, and you took them to her mother's, isn't it true that you know that she and her mother don't get along and she wouldn't have wanted them there? Isn't that true?
No.
Okay, well, that was her testimony, that's why
Okay.
she went to go pick them up, because she was surprised that they were there. They were supposed to be with you. Isn't that true?
Yes.
Okay. Okay, so, and ultimately, you really had no business being at the scene on that evening. Isn't that true?
No.
Well, Amanda had possession of the children according to the court order. Isn't that true?
Yes.
Okay, so if she had possession of them, she can have them wherever she wants. Isn't that true?
Yes.
Okay, and you had no business getting in the middle of that. Isn't that true?
Yes.
Okay, thank you. I'll pass the witness, Judge.
All right, Mr. Ramirez, I guess you're representing yourself. So this becomes kind of a unique situation, but do you have anything else to add?
No, sir.
All right. Have you ever been, how many times you say you have a volatile relationship with Miss Alvarado. Is
Yes,
that
sir.
true? All right. And you said that on multiple times you've been assaulted. Describe the assault.
Like when we were in the room, like she wouldn't let me leave. Like she would hit me, she would grab me. I would even have to yell out for her mom to come and get me.
You lived with her mom?
We used to like stay for a month together.
And so you've been physically attacked or physically assaulted by Miss Alvarado?
Yes, sir.
Okay. Anything else, Mr. Ramirez?
No, sir.
All right, Ms. Pettis, anything else?
No, Judge.
Any other witnesses to present?
No, Judge, that is all. We rest.
And you are asking for a protective order. Let me ask this question, Mr. Ramirez,
Yes, sir.
is Jackson Alvarado, is he your son?
Yes, sir.
And why does he not carry your last name, Ramirez?
You can because the mother never wanted to do it.
Okay, so when he was born,
I didn't. When he was born, I didn't knew I had a son till he was 7 months old. That's when I knew I had him.
she never told you?
No.
Okay, so I assume that who's older, Nathan or Jackson?
Jackson.
Jackson is older. So after that strenuous relationship where she didn't tell you about the fact that you had a child until 7 months after the child was born, you continue to have a relationship with her and fathered another child?
Yes, because I wanted to, I wanted to settle down with her and have a family for the kid. But then things turned worse and plus we got like separated.
So would it be safe to say that during the course of your relationship, you've had a very volatile relationship with the mother of the child, Ms. Alvarado?
Yeah, yes.
Based on your knowledge, why is, from what you know, why does Ms. Alvarado not get along with her mother?
I guess she tells her what to do since she's living there in her house.
She doesn't like to be told what to do.
Yeah,
Okay, why not have a good relationship with her brother?
I don't know. Pues, they want to protect the mom, I guess. I don't know, to be honest, sir.
Listen, Miss Pettis, this is a situation where I feel like a mutual protective order is probably the best course of action. I think that both parties should receive a protective order so that we can try to control the behavior and the and this volatile situation that the parties currently find themselves in. That's kind of what I think, but Ms. Alvarado would like to say something. Ms. Alvarado, you may unmute yourself, and Ms. Pettis, you may ask her questions.
Ms. Alvarado, I guess, do you have anything in response to Mr. Ramirez's contentions that the relationship is very volatile and that you are an
There's
aggressor of the
never a
relationship?
relationship between me and him. I always kicked him out, but I never wanted him there because he had women stalking me and he messed up everything from the beginning. And he was violent. He was the one who would throw things and scream and have my son in the car driving 100. He wouldn't let us get down. He's lying basically the whole time. He doesn't know anything about the situation about at home because he's not there. He only hears my mom's story, but not mine. And the reason that we don't talk is because he doesn't want to. He's not mature enough to talk to me as an adult, just about the kids. And I never hit him. I never kept him inside my home because for starters, I didn't even want him in my home. So I don't understand why he has to lie so much that I hit him with the phone, because I actually had the phone with my aunt on the line, hearing everything. And she heard him hitting me and she was telling him, Joe, stop hitting Amanda. And she heard him hit my son too. He pushed him to the sidewalk because he was hitting him.
And Ms. Alvarado, did you hear the judge where he's inclined to order a mutual protective order against both of y'all? What are your thoughts on that?
Well, I think that's ridiculous because I don't even get near him. I don't talk to him. I don't want to talk to him. I don't want him to get near me. That's the reason why my mom would do it for me. But then he started telling my mom that he would pay her if she took care of the kids, because obviously even on his days, he can't make it. I've been making reports. He doesn't make it on every Thursdays. He doesn't make it on his weekends. It's only when he wants to pick them up.
Okay.
And everything's in his control, and it's not going to be like that. It's going to be by the child support, the way the judge says, and he doesn't follow any of those since Jackson was a baby. And the reason that he didn't know he had a son is because I wasn't sure who the father was.
Okay.
He came to me and I said, okay, well, let's do a DNA test. I agreed to everything. I did everything the right way. I met his family. I wanted to see where my son was going to be. But that I ever wanted a relationship with this man, I never did. So hitting him is nonsense. I have no need to hit him. I just want him out of my house. I just need to know that my kids are going to be safe with the people around him, and his parents are great. Okay, they're safe there.
Okay.
But yeah, no, I don't agree to that because he's talking about stuff that's not true, doesn't matter. And he doesn't see the things that my brother does at home, like all the violence. He broke my arm, my ribs.
Who did that?
My brother.
Okay, but you don't live in the home with your brother anymore.
No, I got out that day because my kids should not be going through that. And I explained to him. I told him every time And he chose not to trust me. He chose to trust my mom more. And I said, they're my kids. They're not my mom's kids. They're mine. My responsibility. Now I'm trusting you to take the kids to a safe place. And he took them back. When I told him the
Oh.
situation, and I told him that I was going to be staying at my aunt's house, and he did not reach the kids not once after the incident.
Okay, so is that the
But he
reason why
made a
you don't?
report saying that I was interfering with child custody, but did not even try to look for his kids. Does
Okay,
that
Ms.
make any
Alvarado,
sense?
so is that the reason why you didn't want the kids at your mom's house, was because your brother was there?
Because there's too much violence, there's too much fighting, there's too much. My kids do not want to be there.
Okay,
They even told their dad that. He knows that. They want to be with me. They don't want to be with my mom or Danny. If you talk to my kids, they'll tell you right now that they hit me. Like, if you're, Nathan told Danny, if you ever hurt my mommy, I'm going to hit you or something like that. And he shouldn't be saying stuff like that. I'm trying to get him away from all this stuff so that they can be good and happy and normal kids, happy and a happy home. It shouldn't be like this. So that's what I'm doing right now. I'm taking responsibility for everything. I'm taking them away from a place that they shouldn't be in. And he's not going to control my life. I told him that day on Thursday, stay in your car and I'll take the kids outside and we can meet halfway. And he didn't listen. I don't want him near me. And he went straight to the house, knocked. My son opened the door. And honestly, I was scared for my life.
okay, when you're saying he, who are you talking about?
Joe, Jose Luis.
Jose
I told him
Luis,
to stay in
okay.
the car and I would take, because of the protective order, and I would take him the kids halfway. But he didn't listen. He always does things his way. And it's not going to happen just when he wants. It's going to happen the way the judge says and the right way to do it.
Okay,
And honestly, he doesn't even take care of the kids. His mom does. So I don't know why he's even saying nonsense.
okay. I don't have any other further questions from her, Judge. I don't know, whatever. Oh, and so if Ms. Alvarado, if the judge does order that it is a mutual protective order, you will respect his order and you
Yes.
will follow the order as the judge says. Is that correct?
Yes, ma'am, I will.
Okay.
All right, thank you. You know, the court has always, when I was a lawyer and all the, hearings that I would have, I learned from some of really good judges who I presided in front of, who would tell me that when it comes to protective orders are orders that are there not to gain a advantage one way or the other. When it comes to children, they're there to protect the individual and the children. And I would always hear from them how, it was funny because, the number one question was, do you plan on hitting your wife or do you plan on hitting your husband? And the answer was always no. And therefore the follow-up question was, well, then why have such a problem with a protective order if the protective order is there to protect the children and the individual? And it just seems that when people are on antagonistic sides, it's a sum zero game. I want to come here, I want to win, I want to bury the other person. I have anger, I have frustration, I have built up emotions. And one of the things I've always said is, as judges and lawyers, we try to not be emotional about situations because we're not the ones who are involved. And that's why it's always good to be represented by counsel, because an attorney is not an emotional person in the situation. So they can bring logic and they can bring knowledge and they can bring years of experience to the table to try to resolve people's issues when it's a very emotional state. Family law is the most emotional state of any type of cases that you can possibly imagine, even over civil cases where we're dealing with money, because here we're dealing with children and we're dealing with relationships and we're dealing with failed relationships and we're dealing with, if y'all were getting along, I tell people, if y'all were getting along, we wouldn't be here, right? And it doesn't matter. This issue wouldn't, married couples put up with a lot of frustrations and stuff, but until it boils over to a divorce is filed, then we start to talk about all the brokenness of a relationship. So in this situation, the court feels that a mutual protective order is probably in the best interest of all parties, because nobody intends to, I would hope, to assault another person. Nobody intends to utilize the children as a sword or a shield, and nobody intends to communicate in a harassing manner. Nobody intends to communicate through text in a harassing manner. Nobody intends to cause physical harm or bodily injury to another person. And that's what's being checked off here, right? That you not do those, that you don't go to the residence and the workplace and harass another individual, that you don't send text messages to another person. And so for that reason, I just don't think that, and I'll look at this again, because, for example, a protective order does go into issues of whether or not it allows Mr. Ramirez to carry a firearm, things of that sort. And so I think that this is more of a restraining order than a protective order, and it should be a mutual restraining order so that we can get away with some of the restraints that a protective order, does. I think that the parties here have a failure to communicate problem, and they don't have, and I think that they both understand, and from what I gather, Ms. Alvarado feels that Mr. Ramirez is a good father because, he has a relationship now, whether he exercises that relationship or has other obligations, and maybe leaves the children in the care and custody of somebody who she doesn't approve of. Well, that's something that, through the SAPSR we need to work out, right? But that's a modification of the SAPSR. That's another gamut. So let me see here. Mr. Ramirez, do you own a firearm?
Yes, sir.
What do you use that firearm like?
For protection.
What are we talking about? Like a 9mm or something, or what?
Yes.
You have
So a Glock, it's a Glock 40. It's not a 9. It's a Glock 40.
all right. Do you have a concealed handgun license?
Not right now. It's suspended. But I used to have one.
Why was it suspended?
Well, it's expired.
Oh, okay, it wasn't expired for any
No.
violation or anything. Miss Alvarado, do you own a firearm?
No, sir. I don't like guns.
Ms. Pettis, I'm, right now I'm kind of on the fence as to whether or not to include that provision of the firearm. Do you have any input on that?
I think maybe her main concern would be like having it around the children.
Yes.
So as long as he doesn't have it around on his possession during his visitations with the children.
Do you have it in a locked box at home, Mr. Ramirez, or where do you have it?
Yeah, I have a safe at the house. And when the
But he
kids go
keeps it
home,
in
I
his
always
car.
put everything inside, even the knives and everything, because they're kids. They play and they think it's toys and they can get hurt.
What kind of knives? Are we talking about steak knives, kitchen knives? What are we talking
Oh
about?
no, like regular like
Hunting
knives,
knives.
just the hunting knife, the butcher knives and stuff like that.
You have a lot of those?
No, I have like 4 or 5. I hunt and stuff. I fillet knives and stuff like that.
All right, Ms. Pettis, can you work on an order that includes that he not possess the firearms or any knives while in the possession of the children? And that,
Yes.
and obviously, we'll take out the not possess a firearm or ammunition, because it does go to that in a very restrictive way. I think that we should, it's going to be a mutual protective order. We'll leave out that provision and we'll modify it to include that he is not to possess or have any firearm or ammunition while having the custody of the children, or any hunting knives or any game knives, fillet knives or otherwise.
Or in his car.
Yeah, or in his car. Yeah, anywhere when the children are around.
Okay.
Because he always
And-
has one in
And do
his
you
car.
want both parties to sign off on the order?
Um,
Or do you just want me to
No,
submit it to you and,
just submit it to me, I'll review it and then I'll sign off on it.
okay. Will do.
All right, any other questions, Mr. Ramirez?
Would I be able to still see my kids or I gotta wait?
Yeah, absolutely, no, that continues,
Okay,
doesn't
so this
change.
Thursday I can go pick them up,
yes.
but can we do like, where do I pick them up or what's the?
So, yeah, so, I mean, Ms. Perez, we should put in there a provision that they can communicate, but only for the pickup and drop off of the minor children.
Okay.
Where do y'all typically exchange the children?
At her mom's house.
I mean, that's
Okay,
gonna be
we
a
don't want to
problem.
do it there.
Yeah, that's not
Can we
gonna
do
happen.
it wherever else?
Your
Mission
mom's house,
PD?
yeah, we can do
Right now, I'm
that.
at Eliel's house, which is where the protective order is at. He's not allowed to get close to his residence.
Okay, so let's do a pickup and drop off now. And this is one of those modifications that we're gonna have to kind of go back and modify the original order, right? Or enter into some sort of agreement that the pickup and drop off, let's do the police station in Mission, right? Y'all are from Mission or Sullivan?
Yeah,
Well, Peñitas.
Penitas?
we can do it Peñitas. I don't mind.
The Penitas Police Department?
I don't mind it.
Ms. Alvarado?
I'm
you
sorry, I
okay with
couldn't hear that.
The Penitas Police
Cutting off.
Department, pickup and drop off,
Mm,
going forward.
Yes,
Okay,
Okay. I'll put that in the order.
okay. Anything else that we anticipate? Ms. Bettis, anything else that you can anticipate or you think?
Not right now. No, Judge, I can't. No.
Okay, all right.
Okay.
Submit an order, I'll sign off on it, Ms. Bettis.
Thank you, Judge.
Thank you.
All right. Bye-bye.
All right,
May we be excused?
your excuse, thank you so much.
Thank you.
All right, Mr. Gomez, I'm sorry I kept you waiting, and were you able to confer? You're on mute, Mr. Gomez.
You're doing the same thing I'm doing, Sam. You're in another court too, right? Yeah, I'm in the 464th. I'm waiting for that.
Your Honor, we would like to come back in 30 days, Judge. The issue here, Your Honor, my client, like I said, he hasn't seen his children in quite a long time. He did move up to Houston for
We just
work.
got the temp order in November.
So
it's okay if we
what
set it,
we're hoping is that we're going to be able to agree on something where my client will be able to have a relationship with his daughters, to be able to see them. They're I believe 14 and 7. And so to either maybe once a month or once every 2 months, that he actually be able to have a weekend in person with his daughters. And Mr. Gomez also mentioned possibly doing virtual communications. So we would like to come back in 30 days, Judge. We're going to try to hammer out an agreement, and if we cannot, we'll take it to your honor. But at this time, Judge, we would ask that the court reschedule this case for another 30 days.
Your Honor, I have no objection to a reset for 30 days, but I do want to get on the record that the reason he's not seen his children is he removed himself from the children and went to the Houston area. He has no documents, so he cannot come back because he can't again cross the checkpoint. So it's a situation he's created, not that my client has created.
Yeah.
And if he wants to have any type of personal contact, he's going to require that, or he would have to require that my client drive and expend funds. And I'm saying that's onerous and improper, in that he created the situation. So he would have to compensate or defer the expenses that my client might have to incur. And I've not yet spoken to her about that. So we still have to see what my client would say with respect to any contact visits.
Yeah, I mean, that seems like, I mean, again, I'm speaking here based on what y'all have told me, right? That just seems like the most reasonable expectation, Mr. Reyes, that she be compensated for taking the children, north of the checkpoint, because he took himself north of the checkpoint by whatever means were necessary to get himself north of the checkpoint, and now coming south of the checkpoint exposes him to risk of not being able to return, and so he finds himself in no man's land, and so therefore he would like to have visitations. I understand that, but to meet somewhere in Corpus, for example, or Victoria, somewhere in between, would expend resources and costs to the other party that he would have to compensate. I see that as being a very reasonable request. So please know that in the conversations that you have with your client.
Yes, Judge, I understand.
Okay. Definitely not a problem with the reset, Mr. Alcantar. Any dog in the fight or anything that you would
No,
have?
Your Honor, we don't have any objections either, and they were
Okay.
going to provide us with this income, so we don't have any problem with that.
Perfect. Let me give you May the 9th, if that day works for the three of you. May the 9th at 9:30.
That'll work, Judge.
Okay. Unless I hear an objection as to that date, we'll see you all on May the 9th at 9:30.
Be excused.
You may be excused. Thank you, gentlemen.
Thank you very much.
Okay, I have a Isidro. Isidro, what case are you here on? Isidro, can you hear me?
Hi, it's Sam Reyes' client.
Oh, that's Mr. Reyes' client? Okay, Mr. Reyes, nos vemos el día 9 de mayo, por favor, a las 9:30. Sea en comunicación con el señor Reyes.
Ok, gracias.
De nada. Okay, let's go back to Mr. Chapa and Mr. Benavides, if they're available.
Your Judge.
Okay, gentlemen, are you all prepared to go
Judge.
forward with the summary judgment?
Yes, Your Honor.
I'm ready to proceed, Judge.
Okay, this is CL 1942-96H, Santa Cruz, as legal representative of the estate of Nora Martinez, deceased, versus Walmart. Mr. Benavides, I assume that this is your motion?
Yes, Your Honor. It's a combination traditional and no evidence motion for summary judgment.
You may proceed.
Thank you, Your Honor. Just by way of background, Ms. Santa Cruz is suing Walmart on behalf of the estate of her mother, who passed away for unrelated health reasons. Ms. Cruz is asserting claims for negligence, premises liability, and gross negligence in connection with an incident that occurred on August 13, 2017, in which her mother tripped and fell over a rolling bicycle rack that's used to transport bikes from the receiving area of the store onto the sales floor. I think the first thing that the court needs to determine is the nature of Ms. Cruz's claim, because she's pled both a negligence, i.e. a negligent activity claim, and a premises liability claim. Now, Texas case law is very clear that depending on the circumstances, a person injured on another's property can have either a negligence or negligent activity claim or a premises liability claim against the owner. When the injury is the result of a condition on the property, premises liability principles will apply. When the injury is the result of a contemporaneous negligent activity on the property, then ordinary negligence principles will apply. Now, the Supreme Court has told us that these two theories are separate and distinct theories of recovery, okay, that require proof of different, albeit somewhat similar, elements, but they're not interchangeable. In other words, you can't have one or the other. It's one or the other. You can't have both. And the facts don't interchange between the two theories. Our own 13th Court of Appeals is recently, it's 2019, in the case of Alvarez versus Salazar Davis, which is cited in our motion, explain this. So, you know, I think the first thing the court needs to do is make a determination as to what type of a claim she actually is presenting. Now, if the court were to look at her petition, I think it's pretty clear that she's making a claim that sounds in premises liability and not negligent activity. If the court would allow me to share screen. Let's see if I can do this.
Go ahead. It's open.
Thank you, Your Honor. I'm a little technically challenged, so. Okay, can the court see that? Mr. Chapa, can you see that?
I can see it.
Okay, good. These are the allegations from section 5 of the plaintiff's petition. And if you look at the allegations, the claims are based on Walmart's alleged failure to inspect the dangerous condition created by the obstruction, make a proper inspection of the store's premises, properly and adequately discover the dangerous condition created by the obstruction, to warn plaintiffs that there was a dangerous condition created by the obstruction, to place warning signs or barricades around the obstruction in the store aisle, and to correct the dangerous condition existing in the store. So as a preliminary matter, all of these pleadings go to a premises defect or premises condition, okay? There's nothing here that indicates any ongoing activity being performed by the store or that she was injured by any ongoing activity. Let me get out of this. Now, if we go past the pleadings, because I understand that, plaintiff can amend their pleadings at any time. But if we go past the pleadings and focus on the evidence that we've accumulated so far, the only evidence that we have really is the testimony of Ms. Cruz. She was with her mother on the date this incident happened. Unfortunately, Ms. Martinez passed away before, I'm not sure if it was before the initiation of the lawsuit or if it was after, but in any event, we were never able to meet and get her story of what happened, unfortunately. So we just have Ms. Cruz's testimony. And if you look at the deposition testimony from Ms. Cruz, and in our motion, we've cited specific testimony from her that describes what happened. Basically, she describes that her mother and her were walking down an aisle, the rear, what they call action alley, which is one of these wide aisles that goes from left to right of the back of the store. She turned left and tripped over this rolling bike rack that was situated between two pallets, and I can show the court one of the pictures of this. This is the rolling rack that she tripped over. She tripped over the bottom bars of this rolling rack, okay? She didn't testify that a Walmart employee was doing anything at the time of this incident. She didn't testify that, for example, a Walmart employee was pushing the rack and hit her and knocked her down with it, or was in the process of removing bikes from the rack. And you can see the hooks at the top for the bikes. There's no testimony or evidence that anything like that happened. If we had something like that, then yeah, we'd have a negligent activity claim, but we don't. The only thing we have is that she tripped over this rack. So based on the evidence, whether either under a traditional summary judgment standard or a no evidence summary judgment standard, I think the court can grant summary judgment because Ms. Cruz's testimony disproves a negligent activity claim. And under a no evidence standard, there is no evidence to show that Ms. Martinez was injured by a contemporaneous with a negligent activity that was being performed. So I think at the very least, even if the court is not inclined to grant a complete and total summary judgment on all claims, the court can grant a partial summary judgment as to the negative activity claim based on both the pleadings as well as, what evidence we have. Now, if we focus on her premises liability claim, it's our position that Walmart is entitled to summary judgment because it did not owe Ms. Martinez any duty to warn or protect her from a condition that was open and obvious under the analysis set out by the Supreme Court in Austin v. Kroger. And the citation for that case is also in our motion. In that particular case, if the court is not familiar with it, the Supreme Court stated that generally an owner does not have a duty to warn invitees against an unreasonable hazard or danger under two circumstances. The first is the circumstance where the condition is open and obvious. The second is the condition is known to the invitee. Now, in response, plaintiff says, well, let me take half a step back. The first circumstance, the open and obvious circumstance, that focuses on whether the condition would be reasonably observable to a person exercising ordinary care under an objective standard, okay? Under this standard, whether the invitee sees or doesn't see the condition is not a consideration, okay? It's an objective standard. Now, the second circumstance does focus on the subjective knowledge of the invitee. So, for example, if Ms. Martinez had been available for testimony and she were to testify, yeah, I saw the rack. I appreciated the tripping hazard that it posed, but I thought I could step over the bottom bars and I didn't. Well, that condition, whether it was unreasonably dangerous or not, was known to her and she appreciated it. Walmart is not saying that because we don't have any evidence of that one way or the other. Now, Ms. Cruz testified that after this incident, her mother made the comment that she didn't see it. Well, that's hearsay. And it's not competent summary judgment evidence. In any event, our summary judgment motion is predicated on the fact that, or on what we are saying is an open and obvious condition based on the evidence that we do have. The evidence does show that this bike rack was 7 feet in length and 6 feet in height, okay? That's 3-inch aluminum tubing, okay? The bike rack was not hidden. Ms. Cruz testified herself that the rack was large in height and the area was lit, so it wasn't too dark to see. Ms. Cruz also testified that she herself did not see this rolling bike rack before her mother tripped over it because she wasn't paying attention. And she gave no other reason at her deposition why she failed to see this. So under a traditional standard, we believe the evidence shows that the bike rack was an open and obvious condition as a matter of law, and therefore Walmart did not have a duty to warn her of this condition because the law presumes that she's going to take reasonable steps to avoid the hazards associated with this condition. And if Walmart didn't owe her a duty because this was an open and obvious condition, then the rest of her premises liability claim has to fail and Walmart's entitled to summary judgment. Now, if the court determines that, there could be a dispute as to whether this is an open and obvious condition, and I'm not going to grant summary judgment on that basis. Well, our position would be that Walmart is still entitled to summary judgment under a no evidence standard because there's no evidence that this bike rack posed an unreasonable risk of harm. Okay. Now, the Supreme Court in CMH Holmes versus Danon, I think was the name of the case. It's cited in our motion, has held that a fall in and of itself is not evidence of an unreasonable condition. People fall down for various reasons all the time. A fall in and of itself or an accident by itself doesn't support negligence. There has to be something more, okay? And what that something more is, there has to be evidence that there was some inherent aspect of this bike rack that presented more of a risk of harm, an unreasonable risk of harm, as compared to other racks, other displays, things of that nature. And in this case, we don't have any evidence of that nature. There's no evidence that the rack was damaged. The photograph that you're looking at here, Your Honor, shows the condition of the rack at the time, the condition and the location of the rack at the time of the incident, or shortly thereafter, I'm sorry. There's no evidence that the rack was damaged or modified in any way so as to present more of a tripping hazard. There's no evidence that it was modified in any way. There's no evidence that the manner in which it was situated in this alley presented more of a risk of tripping than anything else in the store. Ms. Cruz testified, and you can see from this photograph, that the rack was situated between two pallet displays. And Ms. Cruz testified that the location of the rack did not impede traffic either behind where they were walking or in front. And I've got a better picture here. Okay. Ms. Cruz testified that her and her mother were walking along this aisle in the direction of this red arrow. Her mother turned left and tripped over one or both of the lower bars, okay, and fell on this side. She testified.
Mr. Benavides, are you showing a picture right now? Because I'm not seeing it.
Oh, well, I'm trying to.
Neither.
Hang on one.
I just see it like a desktop.
Okay, well, I'm not sure why that's happening. Let me try something else, Your Honor.
I know which one you're referring to, but I just want to make sure the court's seeing it.
Yeah, let me see if I can. Can the court see that?
No.
Okay, let me try one more thing then. Let's see. How about now?
Nothing.
No, I'm not sure why it's not doing that, Your Honor, but I'll go back to, how about there?
Nothing.
Okay, let's see.
Now, yeah, now you exited the hole. But maybe if you do it again and open up another, I mean, you did a great job opening up the previous one. I was able to see that.
I tell you, technology, it's either your best friend or your worst enemy. Let's see. Let's try this. No, it's not going to do it. Oh, well.
Mr. Chopper, I'm not going to have it.
Actually, I might. So I can blow it up here. Can I share my screen?
Yes, of course. It's anybody can share it at this point. It's open. So how about Mr. Benavides? How about you close? That's your.
Let me stop my share. There we go.
Yeah, there we go.
Can the court see this one?
No, maybe because Mr. Benavides hasn't closed his. All it says is Billy Chapa has started to share screen, but nothing else is. It's a black screen.
Well, that's okay, Your Honor. I'll move on. I don't want to take up too much of the court's time. But if the court,
I think Mr. Chapa's frozen, Mr. Benavides. Give me 1 second.
All right.
Yeah, now I think he froze.
Wait, I think I'm back.
That may be the issue. There, I think you're back now.
Okay.
Oh, there we go. Now we're getting some. We're getting somewhere, Mr. Chapa.
Can the court see my screen?
I can see the screen that you opened it up and that you're now looking at like a menu. But there's no photograph or anything. It's just a.
Yeah, that little menu's covering it for some reason. Now this is messing up. Okay, there we go.
Oh, there we go.
Oh, there we go. Okay, thank you, Mr. Chapa. If the court will look at this exhibit from Ms. Cruz's deposition, it shows the same bike rack. The arrows, the red arrows indicate the direction that they were walking along this aisle of the store. And you'll see that they were walking from right to left of the view screen when Ms. Martinez turned left and tripped over the lower bars of the rolling rack. Now, Ms. Cruz testified that the location and position of the bike rack did not impede traffic either behind it or in front of it. So in short, there's no evidence that there was anything wrong with the bike rack, that it was damaged, modified, or that it was situated in a manner so as to present a higher or unreasonable risk of tripping as compared to other racks in the store or other displays.
Mr.
So-
Benavides, let me ask you this question. Was it brought up, and maybe Mr. Chapa will bring this up, because the most blaring issue that I see isn't the rack itself, it's the color of the rack and how it blends in with the floor. I mean, was that brought up? Is that an issue?
I think in response, that's one of the questions that were raised. And all I can say to that, Your Honor, is that this is not a small rack. This is not like a clothing rack. This is a rack that is about 3 feet in width, 6 feet in height, and 7 feet in length. It may actually be a little bit over 7 feet in length.
Yeah, but the question, and I understand the size of it, but when you're coming up on it based on the arrow, and then you immediately, not anticipating that there's something there, and then immediately hang a left to cross from one aisle to another, to cross that little median, if you want to even call it that. The issue here is, why wasn't that a yellow bar, or why wasn't it a red bar, or so? Why wasn't it painted because it just seems to me that it's blending in with the floor. But that's just, again, I don't know if that was brought up, and I suspect, Mr. Chapa, you nodded in the affirmative that that's going to be something you bring up. But
That's
Yeah,
right.
and in response to that, Your Honor, I mean, that really, well, it can't really go to the question of whether Ms. Martinez saw it or not, because our motion for summary judgment is not based on her subjective knowledge of the condition. It's really the objective standard. Does the size and dimensions of this bike rack make it open and obvious? I mean, as compared to other racks, what makes this bike rack more unreasonably dangerous than, let's say, a clothing rack that doesn't have any clothes on? There's been no evidence of that. There's no testimony from anybody saying, as you're alluding to, oh, the bars should have been painted yellow, or they should have been painted red, or there's no evidence of that whatsoever. The only reason that Ms. Cruz didn't see it was because she wasn't paying attention, plain and simple. And we don't know why Ms. Martinez didn't see it. She's not here to testify. And anybody saying, well, she said this or that, that's not competent summary judgment evidence. So unless there's evidence showing some evidence, at least raising a question of fact as to why this bike rack would present more of a risk of tripping than any other rack in the store, summary judgment has to be granted on that basis. Now, the last thing is with respect to her gross negligence claim. simply put, there's no evidence that Walmart acted with conscious indifference. To begin with, the pleadings, when basically what they do is they say, well, we're going to base our gross negligence claim on the same facts that we're basing our negligence of premises liability claims. There's no additional allegations or facts that would allege that Walmart acted with conscious indifference. And keep in mind, I mean, for gross negligence, you've got to have pretty strong proof, but we don't even have the allegations for that. But even if you get past the pleadings, there's no evidence of that. There's no testimony from anybody one way or the other that would support a finding of gross negligence. So I think in sum, Your Honor, well, and I know that in her affidavit, which we've got several objections to, and I'm going to let those objections stand on their own and simply ask the court to review our objections to Ms. Cruz's affidavit and issue a ruling sustaining those objections and not give her affidavit any consideration at all for the reasons set out. But the only supposition that Ms. Cruz presents in her affidavit in support of a gross negligence claim is her belief that Walmart was aware that people could get hurt with the rack, but did not care to move it. That's just rank speculation. It's not based on anything. It's her belief, it's her thought, it's conclusory. There's nothing to back that up or support it. And other than that, there is nothing that would constitute competent summary judgment evidence to support a gross negligence claim. So I think at the very least, the court should give serious consideration to granting summary judgment on the negligent activity claim as well as the gross negligence claim. If the court feels that there's some question with respect to the premises liability claim, that claim can move forward, but at least the case as a whole will be cleaned up and we won't run into the possibility of going through a jury trial and then an appeal and having a court of appeals reverse and render because the wrong instructions were given to support whatever verdict comes out. We don't want that. I don't think anybody wants that. But I also think that either under a no evidence standard or a traditional summary judgment standard, Ms. Cruz's premises liability claim can be dismissed. And with that, well, I'm already sitting down. With that, I'll sit down and be quiet.
All right, Mr. Chapa.
Judge, and I'll be very brief about it. Going back to the beginning of the defendant's argument.
And I hate to interrupt, but if you're not going to be using this, it's always better that I see you a little bigger than just over on the side. If you don't mind closing it. If you're not going to use it, if you're going to use it, then by all means.
I'm going to reference it, Judge, but I'm pretty sure the court's already knows what I'm talking about here.
Yes, sir.
Here, maybe.
Perfect. There we go.
So going back to the beginning of Walmart's argument, Judge, as to premises liability and negligent activity, the case that Mr. Benavides is referring to, I believe it's Keach v. Kroger. That's a Supreme Court case. I interpret that case to have a different meaning. I don't believe that it necessarily rules that it has to be one or the other, but I will leave that to the discretion of the court. Getting to I guess what the court alluded to earlier, the big issue here is whether this bike rack was open and obvious, whether it was an unreasonable, dangerous condition. And as the court noted, I'm trying to pull up the picture on my other screen here. As the court noted, the bike rack in question here, it's does pose a unreasonable risk of danger. It is not open and obvious. And I understand that Walmart is basically arguing that it's a 7-foot tall bike rack. It's large. There's no way that no one should have seen it. They should have appreciated the danger. However, it's empty and hollow. It's gray. It blends in with its surroundings very well. It's almost basically identical in color to the floor. It's surrounded by other bright colors, palettes that are meant to get your attention. Say, oh, low prices over here, fancy objects over here, come buy this, come buy that. And when a person's walking through the aisles and through those in Walmart or whatever other store, they're walking through, they're assuming that there's not going to be anything in the way. I know in the defendant's reply, they make mention of a 7-foot tall, not the same thing that we're talking about here. If a person's walking and there's a 7-foot tall person right in front of you, you're going to see that. However, just as the court saw, the bike rack is completely hollow. There's nothing at eye level when you turn into that passageway. There's nothing at eye level that's automatically going to get your attention. And I think that's the biggest issue here. I think that the affidavit in support of a response creates the issue of fact in this case.
Now, hold on, Mr. Chapa, but okay. And so then that brings up 2 points, right? First point is that I look at that picture and I'm looking at it over here on a side screen. And I would agree with you, Mr. Chapa. If you're looking at it, there's bars on the side, right? There's the bars, but they're up against the 2 pallets. And then there's empty space in the middle, and then the bars on the floor, right, that match the ground. And so I look at that, and that was the most glaring thing that I was able to bring up, because initially my thought process went straight to that. You know, you go to Lowe's, for example, and Lowe's has flatbeds, and then they have these little carts, dividing carts to take lumber. But Lowe's paints them blue, Home Depot paints them orange. And there's a distinct color that those 2 companies have chosen to not blend them in, I would assume, with a concrete floor, because they all have concrete floors. So I get that, but that only goes as to the premises liability, right? That's the issue of premises liability. And so I would kind of, to tip my hat off a little bit, I'm inclined to look at it and say, okay, premise liability, summary judgment denied, but negative. I think you Mr. Benavides, you called it a negative activity, but then Mr. Chapa called it a negligence activity.
Negligent activity.
Negligent activity.
Negligent activity.
So the negligent activity, Mr. Chapa, I'd like to hear more on that, because I'm not convinced on that. And the gross negligence, if you have anything, or if y'all are just abandoning that and saying, Judge, we understand that Walmart didn't intend, they weren't out there trying to cause people to trip. The gross negligence and the negligent activity, that's where I want to focus my attention more on, not the premises.
Right.
But maybe it's one of those situations where, listen, Judge, we appreciate that you see it the way we do. And so therefore, if, like Mr. Benavides says, if we're going to clean this up for a jury, as long as the premises liability, which is really the crux of it, I think, of our argument, as long as that's going to be able to be presented to a jury, because there's a fact issue there, then we're okay with the gross negligence being granted and the negligent activity being granted. But I don't know. I mean, I haven't heard anything from you. I just want to steer you away from the premises and not waste 30 minutes because I'm already kind of thinking the same thing.
Right, Judge. And I understand, and I understand Mr. Benavides' argument. I do not want to flat out abandon the claims. However, if the court were to rule that way, I would completely understand the court's reasoning. The affidavit in support of our response does reference those 2 claims, does touch on them, but as the court's mentioning, it's not the primary issue in this case. And I do agree that if the court were to be inclined to grant Mr. Benavides' motions as to those 2 claims and not the premises liability claim, I do agree that it would clean it up for a jury, Judge.
Right, and that's kind of just where I didn't want to waste any more time. I kind of feel like, hey, listen, I see that, and I think that that's a jury question, jury fact question about, you know, is it open and obvious? Is it something that Walmart should have maybe painted a different color? But is it gross negligence? I don't think so. Is it negligent activity? Were they doing anything to create that harm at the time? I don't see it. I don't think so. From what I see, it was just a rack that they left there, and maybe they should have painted it a different color. Maybe they should paint it orange. Maybe they should paint it blue. Maybe they should paint it red. And maybe in retrospect, maybe they choose to do that. Maybe they don't. But you know, that's more. I don't think that's a negligent activity issue. I don't think it's a gross negligence issue. I think it's a premises liability issue. And I mean, I haven't heard enough to overcome and say, you know what, deny the summary judgment on the negligent activity or the gross negligence. But I also interrupted you, and I don't know if you were done with your argument. But I wanted to steer you towards
Judge,
that.
That's really the argument as to premises liability, Judge. I think it speaks for itself. Just the pictures that were presented. I think there's a clear issue as to that claim.
Okay, so as to that claim, the summary judgment will be denied as to the premises liability. But what about the negligent activity and gross negligence? Anything else to present? Any other evidence to present?
I have nothing at this time, Judge.
Okay, so then as to the negligent activity part, Mr. Benavides, as well as gross negligence, the summary judgment will be granted. So that'll hopefully clear this up and clean it up a little bit.
Yes, Your Honor.
So
Yeah,
if you could provide me with an order.
yes, Your Honor. I'll prepare an order and get that filed. I'll try to do it before the end of the day. I did want to let the court know that we have mediated the case. I think we mediated it about a month ago, maybe 4 weeks ago. After the mediation was done, I did extend a new settlement offer. I've not heard back from Mr. Chapa, but he's been really, really busy. But I would ask him to present that, if he hasn't done so already, to Ms. Cruz and get back to me with a response. Because if we can get this taken care of sooner rather than later, that would be my preference.
And just so you're aware, Mr. Benavides, I did get the offer. It's been relayed to our client. I just haven't had the chance to really. It's been a crazy couple of weeks so far.
I understand.
I'll get back to you. I think we're not far.
Very good. Yeah, no pressure. Just whenever you can get it to me. That way I can let my folks know that we're still talking and we're still trying to work things out.
Yes, sir.
Okay, so negligent activity, MSJ granted. Premises liability, MSJ denied. Gross negligence, MSJ granted. That clears it up, and if you can submit an order, that would be great, and we'll work accordingly. I think this one already has trial dates.
I don't know that we've gotten a, let's see.
I think a DCO might have been submitted.
I think we just recently got a trial date. One moment. And
January of next year.
January, yeah.
Yeah, plenty of time to get it worked out.
Yes, sir. And it is an older case, so hopefully it'll have priority when we get to that, if we get there.
Very good, Your Honor. I have nothing further. May we be excused?
You're excused. Thank you, Mr. Chapa.
Thank you.
Yes.
Yes, Judge. Thank you.
Have a good day.
You too. All right, that takes care of our docket.
Judge, number 6 and number 7.
Right. All right, number 6 and number 7, CL 21-1400H, Bank of America versus Abigail Rios. This was set for default judgment hearing. This is going to be set for dismissal for warrant of prosecution since no one appeared. On what day?
Yes, just put that for the 11th.
May 11th, 2022, 9:30. And the same goes for number 7, CL 2136. I'm sorry, 3206. That one would be set for DWAP. That's Bank of America versus Isela Perez. Set for DWAP. May 11th, 2022 at 9:30. All right, that takes care of